So good afternoon, dear colleagues, the public and the candidate. The advisory group of experts gathered in full to conduct an interview with a candidate for the position of a judge of the Constitutional Court of Ukraine, Mr. Kostenko Vladyslav Kostenko. He was admitted to competitive selection by the decision of the Council of Judges of Ukraine. Mr. Kostenko is a judge of the Kopkatisky District Court of Sumy. We are ready to start, and I will give the floor first to the Secretary of the Advisory Group of Experts, Mr. Yaroslav Romaniuk, to explain the algorithm of our work today and to moderate the interview. Please, Mr. Secretary, the floor is yours.
Дякую, пане голово. Вітаємо, Владислав.
Chair, good afternoon, everyone. Those who observe our meeting, all 6 members of the AG are present at the interview in person or by means of communication technologies. Also, 5 deputy members of the AG are present. Participate the chairman of the AG, Alex Zalev, the members of the AGE, Madam Hanna Sukhotska, Madam Marina Connor, Madam Oksana Vasilchenko, the member of the AGE, Mr. Vasil Shakun, and myself, the secretary of the AGE, Yaroslav Romaniuk. Also, during the interview, 5 deputy members of the AGE are present. Thomas Griffith, Richard Barrett, Marek Zubik, Volodymyr Kuzmenko, and Vitaly Makhinchuk. I will briefly explain the regulatory framework and the procedure for conducting the interview. The interview is one of the mandatory stages of evaluating the criterion of high moral qualities of candidates, and the advisory group conducts interviews with candidates in accordance with Article 7, in particular with the aim of clarifying and refuting any doubts about their high moral qualities. You have already had an opportunity to communicate with the DGE. We sent you a number of questions which you commented in details. We got acquainted with them, and in this respect I would like to inform you that today you would not have any possibility to provide information, documents or other materials during the interview which we asked before, but you didn't provide us with them, or any new materials which you decided to present to us. We may make an exception from the general rule if there are real reasons for this, justifiable. Also want to inform you that the interview is being recorded and broadcast live on the resources of the AG and on the CCU website. Therefore, I draw the attention of the members of the AG and you as a candidate regarding the restriction on the use of sensitive data and information with limited access live. If there is a need to spread such information, we will stop direct broadcasting so that this information does not leave these premises. Vladyslav Gennadievich, we plan to finish your interview within 1 hour, so I ask you to give brief and concise answers to our questions, trying to use maximum 3 minutes for the answer. After the questions are exhausted, we will give you an opportunity to speak to the group of experts. Make a statement not longer than 5 minutes. Now the floor is given to the rapporteurs on your candidature and the members of the HI, Madam Sukhotska and Madam Oksana Vasilchikova. Thank you, Yaroslav. The first group of questions which would like you to clarify is about procuring by you and your family members of cars, in particular Kia Sportage and Nissan Rogue. Tell us, please, the Kia Sportage car produced in 2008, which your family bought in 2010. What were the sources of funds for which this car was bought at that time? Thank you for the question. This car was procured by my mother. She was married to my father, and they bought this car upon my request. They used their own funds. The father at that time was private entrepreneur and a pensioner. What was the reason for your mom to have the property rights, register property rights on herself? Because she didn't have a driver's license at that moment. Yes, she got driver's license in 2011, and the car was bought in 2010. But I will repeat, I asked them. They bought it upon my request. Why did they register this car as their property? Because they used their own funds to buy the car. So she bought this car at her own funds. Is my understanding correct that for 10 years you used that car? Why then you didn't declare the car and the cost of this car? I gave answers to this question because this car was bought in 2010, and that time the order of declaration filling in, there was no requirement to indicate the cost of the car. The documents, the agreement was on purchases of cars was submitted to the police in order to prove the procurement. So in 2016 there were not such documents, and then in 2016 the electronic declaration was introduced, which was more detailed, which required to indicate the cost, and it was indicated that if there are no documents on the cost of the car, so there is no need to indicate. And because I didn't have documents on the cost, on the price of this car, I didn't indicate it, but I've always declared this car which I used. Some other questions concerning another car. This is another car which your mother in 2020 acquired property rights. This is a Nissan Rogue made in 2016. As you indicated, it was procured at the auction in the United States, and in 2020, when your mom registered property rights, you started using that car. We understand that you declared the price to 108,384 hryvnias, and we understand that the car was damaged. Who paid for the repair works? I apologize. May I add something about Sportage? Sportage exists. It has not been sold. My mother is using it. It's a good car and in a good state, well kept. But about the Nissan Rogue, it was bought, and I repaired this car, and you use it. Yes. Why then again you bought the car on the name of your mother? The fact is that at that time I thought that would be a risky procurement. There was a risk that the car, when it enters Ukraine, it could be registered only after full completion of repair. But whether it would be possible to repair it. It would be possible to find out only upon arrival of the car to Ukraine. Also, some funds were needed for in the process of procurement. So I asked mother to help me. The car was procured and brought, and we got access to it. The problem was that the car went by sea, and I was afraid that there might be fungi in the car, and I had to deal with that, and because it would not be registered, so we would lose the car. But it happened that the car came in a good state, well repaired, nice car, and I was satisfied with the procurement. And as far as my mother used this money, I later on gave this money to her and then re-registered property rights, and now this car is in my family. Yes, in 2022 you re-registered property rights from your mother to your wife. Then about this agreement, there is a question: why, when the property rights transfer between your relatives, mother and wife, you used services of the middleman? We could get the agreement of procurement in the service center. That would be free of charge. But the problem is that our service center does not function properly because of air raid alerts, and the service center didn't function normally. And you also had to register in the electronic queue to the service center, but it could be possible to register, but the service center didn't work. And then the representatives who this middleman around the service center, not all of them were able to prepare the agreement because they had problems with some database, and those who managed to register, they registered. Then the question: why the property rights on somebody, not on you, on your wife, but you use this car? My wife got a driver's license in 2009, and as she also used Sportage, and when Rogue arrived, that was her wish. He wanted the car to be yours, to be hers. For me, it was not a matter of principle. She just wanted, and that's it. Hanna, Anna, the floor is yours, please.
Будь ласка, пані Сходська.
Sorry, now you could hear me now, yes? Okay. Yes, okay. So there is also another car. In your declaration for 2023, you indicated that on 21st of January 2019, you acquired the right to use a Mercedes A140, the type of 2000, which is the property also of your mother. And the cost is Ukrainian hryvnia 27,565. At the same time, in 2022, during your interview with the Ethics Council, you stated that you don't use any other car that would belong to your mother except for 2016 Nissan Rogue. Also in your declaration from 2019 to 22, there is no information about the right to use the 2000 Mercedes A140. How you can explain, because it is very unclear.
Yes, Mercedes I got into my use in 2023. The date 2019 is a date when my mother bought that car. That is, the owner got acquired the property right. But the car Mercedes since 2019 was used by my mother, and she didn't want to sell it, and she also had Sportage. So in 2023 in spring I presented this in explanations. My daughter, who is adult, got a right for use of cars, and this car, which is a smaller one, it is used by my daughter, but the daughter lives with me in one family. So I had to declare that car that I also it's in my use. That's this is correct.
We can't understand, yes, your declaration because we had no information in your declaration from 2009 2022 that you acquired the right to use a Mercedes, but in your declaration in 2023 you indicated that on 2019 you acquired the right to use a Mercedes. So there is how to say, very unclear what has happened in between. Now you say that it was used by your daughter. I don't know. We have no information on your daughter here, on your mother and you. So the declaration is not, how to say, correct.
In the declaration, I specify the date when the right of ownership for this vehicle was acquired by my mother. And it was used in 2023, and accordingly I specified that in the declaration. Everything is correct.
For us it was not so correct, and the explanation also does not convince, but we can go next question. And then, according to your declaration, you are still in the declarations of us, for the period from 2015 to 2019, you do not indicate the presence of significant monetary assets in your property or in the property of your spouse. At the same time, during this period, you and your spouse have a fairly high level of annual income. Did you really have no significant monetary assets in your ownership in 2015 and 2019? Because there is no, in your declaration there is nothing, yes? So it's very unusual. But how you can explain it?
In the declaration, I specified everything correctly. With respect to income, yes, really, income was significant, but this income is specified before taxation. So the amount of the funds that we received, which we could freely use, was minus of 19.5%. So that was 1/5 that was deducted as taxes. And I have children, I have family, I have to live on something, I have to use all possibilities that are given to me. We traveled and we fully supported ourselves financially. With respect to amounts, we had these amounts, but they did not reach the required amount that has to be declared. So it was below 50 subsistence minimums. So we had money. It's not that we did not have any money. But the situation changed drastically since 2020. there significantly the judicial remuneration increased for judges of the first instance, so the judges' remuneration increased significantly, and then I started accumulating savings, and in my opinion, quite significant savings. That's the situation.
Would you like to say us that in this period you have no savings because you spend all money for everyday life, for traveling? Yes, this declaration is very, very, how to say, unrealistic, in our opinion. You still confirm that you did everything in a just way. There is the next declaration also. For example, there is a declaration for the period from 2017 to 2021. You declare that you have the right to use an object of unfinished construction, namely a garage with a total area of 18 square meters in sum. The owner is the Sumy city administration. At the same time, during this period, you indicate your membership in the public organization of garage owners, Volna. Under what circumstances did you obtain the right to use the object of unfinished construction? How you can explain it? Yes, because very unusual situation.
The form of the declaration. The form of the declaration that we submit contain a section. One second. Unfinished construction objects. But in declarations we make a mark that the right of ownership for real estate object is not registered following the procedure set out by the law. You correctly pointed out in the question that that you related this garage with Volna cooperative. This garage, I paid for it funds to the previous owner of this garage, and we registered the right based on the right of membership in this garage cooperative. In order to register the right of ownership for the garage, it was also necessary to pass the procedure of privatization and to get the certificate from the city council, but it was not done. And this garage, since the right of ownership for this garage was not registered following the procedure set out by the law, it was given to me based on the membership in this garage cooperative. Nothing was privatized there. And the garage... And the garage itself... yes, it's included into the section of unfinished construction objects, but in marks it is stated that the right of ownership has not been registered following the statutory procedure, but this garage existed. It was a simple metal garage. I think this garage cooperative has existed since the Soviet times.
No, but Mr. Vladyslav, you are a judge. You are a judge with many years of experience and professional lawyer. And you can understand, yes, that the essence of the institution of state registration of ownership, sorry, I lost everything now. It should be registered. And how this situation that you as a judge you have not registered could be seen by others, but from outside, yes, observer. How's your opinion? Of the real estate without state registration, by leaving the garage cooperative. So it is very unclear transaction. So for that reason, how is your opinion?
It's a very common situation, a membership in the cooperative. That's it. Why was I surprised that the right of ownership was registered? It was like a novelty for me. All the garages there were given based on the right of membership, as far as I knew. But I declared the garage in my declarations. This, since the state registration did not happen, this garage could not be identified from some outside sources. But I declared it, I showed that I had it, and I declared my membership in this garage cooperative.
Ситуація не є
Without
And this situation,
Так.
yes, about 4 years, yes.
out state registration, yes. So how it was possible?
The law does not demand registration of this garage. There is a right to use the right and to pass the procedure of privatization. The garage itself could be registered, but it was necessary to undergo the procedure of privatization of the land plot, and I did not do that. I did not need it.
Для того,
No,
щоб
yes,
користуватися
In order to use the garage, I did not need to privatize it.
not private, but you know it was a very same situation. Yes, that you use it, no registration, 4 years. So it is not very clear. But so it's okay. Roxana, now it's your question.
Дякую. Владислав Геннадійович.
Thank you. The advisory group of experts have some questions about closure of procedures due to expiration of the term for imposition of administrative sanctions under cases on administrative offenses set out by Article 130 of the Code of Ukraine on administrative offenses. Namely, we are talking about drunk driving cases. Pursuant to results of analysis of consideration of this category of cases by you, the Secretariat has analyzed the period from 2018 until 2020. And the AGE has some questions about compliance with the term for consideration of cases with respect to 4 cases. In writing, we asked you about circumstances of consideration of these cases, so I hope you remember these particular cases. Can you please tell us, can you please explain to the AGE which actions did you commit as a judge in order to comply with terms for consideration of these cases? Of course, I would like to emphasize again that the AGE does not evaluate or review the court decisions adopted by you. We understand that the court decision in each case is exceptionally the discretion of the judge, and it is an element of judiciary independence. We are only asking about your organization of work as a judge in order to consider these cases on the merits. Which actions did you undertake as a judge in order to comply with the terms and in order to avoid proceedings under this category of cases? I can remind you these cases, or maybe you remember these cases. Thank you for your question. This is a question which is on the one hand is very simple, but on the other hand it is not that simple. The matter is that, first of all, I would like to say that these cases, yes, it's called drunk driving cases. That is Article 130, and it sets out responsibility for drunk driving for avoidance of the conduct of the medical examination. All of these cases have a common element that they were considered in 2019 approximately. There were questions about some previous cases, but roughly speaking, we are talking about 2019 and 2020. Back then, there was existed the procedure of conduct of these medical examinations, recording of facts of offenses. Back then, the procedure set out the presence of witnesses. Now, please understand me correctly. Since 2021, the procedure has changed drastically with respect to the recording and consideration of these proceedings. And now those events which happened before and back then the situation was stranger than now. And agree, judges will understand me. For example, there are some legal positions among higher instance courts, and when the legal position changes, and we had decisions in line with legal positions, and now we have new positions of high instance courts. I would like you to understand me that we are now assessing everything from the perspective of the path of 4 years, and now these cases are considered in a different way. And back then it was 2019. Consideration of cases seems to be simple initially. The matter is that these cases are related to the fact that the person did not admit their guilt, and it was necessary to refute each argument, but after consideration of all the evidence. The code on administrative offenses is a bit outdated from this perspective. And it does not even follow the changes that we have nowadays. I will go away a bit, but I'm the judge of the first instance court. I consider cases following the procedure of 5 codes: civil code, criminal procedure code, the code on administrative offenses, the code on administrative offenses, and the customs code. There is a difference between the customs code and the code on administrative offenses. So it happens that only the code on administrative offenses, for some reason, includes the adverse severity of parties. Basically, the entire duty of public prosecution of the person who has committed the offense is delegated to the judge, and the person who has drafted the report does not take part in the court proceeding according to this code. And if we compare that to the customs code, the state is performing the function of public prosecution. So for some reason the customs code considers that the state should participate in the case consideration, but here in this code on administrative offenses there is no right to challenge the ruling, and only the person under the sanction can challenge this decision adopted by the court. So, okay, let's come back to these 4 cases. Maybe I will tell you in more detail what we are talking about. Under one case, the attorney submitted 3 motions on summoning of witnesses. You satisfied the motion, but the witnesses failed to appear. And now the AG has a question. You, as a judge, from your perspective, took all necessary actions in order to complete consideration of this case on time. Did you take all possible actions? So the judge summons witnesses. These summons were made. Witnesses appear. Sometimes witnesses fail to appear. In these particular cases, witnesses failed to appear, but it was necessary to study the evidence. We also take into account the practice and the case law of the European Court of Human Rights and of the Court of Appeal, and there are also these instances when, if you remember, 1 second, Volchaninov versus Ukraine, that was the case regarding the district court in Sumy region where the judge considered the case and and finally considered the case almost at the end of the term of the consideration of the case, and the European Court stated that there was the violation of the right, and we take that into account. According to this code, if you hurry up, for example, there is a decision that seemingly everything was done correctly, complied with the terms, but the Court of Appeal quashed the court decision because the evidence was not studied. And by the way, again, another interesting situation. If we compare it with the Customs Code, so there is a reason why I am drawing attention to the fact that all of these reports were considered in 2019. Of course, we as judges have learned how to respond to some events, and after 2020 there were no instances like that. And I would also like to emphasize that since 2021 the legislator has also paid attention to the problem of this short period of time during which the offender could be brought to responsibility. And now we have 1 year as the term for consideration of these cases. So the legislator has removed this problem, and I think it was done correctly. My personal opinion is that it had to be moved into the procedure of criminal offenses, because we're talking about serious offenses. But it happens then, since 2020, there were no instances like that. So we analyze the situation and we take all possible measures. Thank you. Ms. Hanna?
Now I would like to put a more general question. So, concerning your thesis, in 2021, you defended your dissertation on guarantees of social security of judges in Ukraine, and you received a PhD doctorate in law from the Taras Shevchenko National University in Kiev. What was the reason for the choice of the topic of this dissertation? It seems interesting, yes, but why you decided to elaborate this topic?
I'm really grateful to you for this question. Yes.
For the choice of the topic of the dissertation.
In 2016, I had experience of working as a judge for over 10 years. Moreover, since 2014 until 2015, I was in the Council of Judges of Ukraine. This is the collective body. And it was really valuable experience that I received. And you know, how to explain? Work of a judge of the first instance court is difficult. Every day you take many decisions. In my explanations, I found over 30,000 decisions that I took. So that is approximately 15 decisions per day, and these were written proceedings. And what I would like to say, there are many more decisions because there are many decisions which are not included into the register, and there are some decisions which are not included into the register at all. So lots of cases. And why am I mentioning this? It is impossible to do all of this work during the working hours. And at the websites of the Council of Judges, you can find that we need more judges than we have now. But I mentioned about this. Why? Because back then in the Council of Judges, we raised the issue about the workload of judges. And for me, it was sort of a surprise after 10 years of work as the judge when we were discussing this with a representative of different projects. So in order to assess the workload of judges, they mentioned the medical criteria as to the number of hours during which the person can work. And I was forced to see after 10 years of work as the judge that the judge is a human being. You know, And the social security of a judge has to be uh, ensured in such a way that a judge should be treated as a human being. And social security has to be resolved in case of judges as well. And during the conduct of this research, I historically analyzed the emergence of this Institute of Social Security, etc. So this topic is very close for me. So I would like to repeat that after 10 years of working as a judge, I thought that a judge is a human being and we should apply the medical criteria, and this are not empty words for me. So that's why that topic was chosen.
As I understand you describe the situation of ordinary judges, not judges in constitutional court, yes, only ordinary judges. Yes,
Tak,
that was
same
my
tak.
question.
Yes, indeed.
Yes, on that as well. No, so I have no more questions.
Чи є запитання в членів до
Any more questions among the members of the group to the candidate? Vladyslav, I have a question to you. Having acquainted with the materials concerning your candidature, the experts draw attention to the fact that in 2022 you were the candidate to the position of the member of the Supreme Council of Justice. You passed ethical council. What was the decision of ethical council concerning you? The decision was that I met the criteria of integrity. Yes, I participated in the election at the convention. At the convention, you were not elected. I was the finalist, but I didn't have enough votes. I had more than 100 votes, but it was something like 140 necessary, but I had only 117. Do you have any more questions? In this case, Vladislav, before announcing the completion of interview with you, you have an opportunity to make a final declaration to the group of experts within 5 minutes. I would like to thank you all personally for answering that challenge and participating in selection of candidates to the position of judges of the Constitutional Court. It's very important and responsible work. Very grateful to you for the experience which I got from you, which I received from you during this interview. For me, it was very important. And I thank you very much for giving me an opportunity to speak. I hope I answered all questions. I got a lot of experience. Learned a lot about my mother-in-law. I did know some things about her, but I will be waiting for your final decision. Thank you very much. Thank you, Vladislav, for answering questions, and you helped us in decision making concerning your candidacy. And on this, the interview of the group of experts with the candidate at the position of the Judge of the Supreme Court, Kostenko is completed. Please leave the room. Give us an opportunity to consult between ourselves.